and censoring films on the grounds that it's obscene. Those standards have somewhat changed in the Supreme Court, and we sort of caught up with the rest of the world. And we no longer accept the older, very conservative notions of what constitutes obscenity. As far as speech against the government is concerned, you can now say almost anything you want to say and get away with it. Defamation, criminal defamation, which was a great restraining statute, which prevented people from saying things openly in society. Criminal defamation, as you know, did not have truth as a defense, so you couldn't say that, well, what I've said is correct. So now truth as a defense in criminal defamation proceedings has come in, and you can say what you like if you have a basis for that statement, and you can defend yourself in court and say, well, what I said was correct. It might have had an effect of, reducing the reputation of a person in the eyes of the public, but what I said was actually accurate and truthful, and it was in public interest that I made that statement. So defamation now, with truth coming in as a defense, has sort of allowed people a bit more leverage in speaking out. As far as speaking out against government servants is concerned, you can say anything because we follow the American standards. That as long as what you're saying is truthful, and even if what you're saying is not truthful, but you did not know that it was not correct, you are completely protected. And if the government tries to sue a person for having made a false statement, the government will have to show not only that the statement is false, but also that the person who made that statement knew that the statement was false at the time when the statement was made. So defamation of public servants, politicians, etc., policemen and so on, has virtually now been rendered redundant. As far as pre-publication injunctions are concerned, our courts were very inclined in the 60s, 70s, 80s to prevent publications from coming to court, to prevent publications from being distributed, and to injunct the distribution of a publication. You know the Stardust case, where the High Court came in and said, well, it's the scandalous stuff about the life of a particular actress, and prevented the magazine from being distributed. By and large now, in the 90s and today, pre-publication injunctions are granted very, very rarely. And the approach of the courts is to allow the publication to go out into society and to leave it open for the person who has a grievance against that publication to file a suit for damages. So pre-publication injunctions is also caught up with the international trend, and the courts are not supposed to generally, except in very rare circumstances, to injunct a publication before it goes out. POTA had the Prevention of Terrorism Act had a very, very dangerous provision which penalized journalists who went out to interview Maoists. So a journalist who interviewed a Maoist and showed, or he didn't even show the clip, just had the clip in his house or whatever, or her house, could be penalized for taking part in a terrorist activity because you've interviewed an insurgent. Likewise, advocates, and we would be drawn into that, an advocate who had a conversation with a militant could be taken under the Prevention of Terrorism Act. The POTA is now mercifully repealed. So those are some of the positive developments that have taken place in the court in the last 10 years. The